Then the other one of the other big constitutional issues that's now up on the plate is the governor of Texas has declared that there is an invasion of the state of Texas. And this triggers two constitutional clauses. One is the federal government's guarantee of both each state government having a republic, which, by the way, is intriguingly part of the suit that New York State court employees are bringing against the New York State court system, claiming that the vaccine mandate is a violation of the obligation to maintain a republic in the state of New York. That was an interesting theory as one of the theories in the suit. But the other provision of that clause is that the federal government guarantees the security of the states in the case of an invasion. But there's another provision that has been loosely called the self-defense clause. What it literally means is a state can declare a state of war. An individual state can. Congress usually has a monopoly on declaring war. Of course, that hasn't stopped us from having all these wars without any declaration of war since World War II, after World War II. But there was no declaration of war for a bunch of these things, but there was military action authorized theoretically. But the states actually have a right to declare war if either they are being invaded or there is an imminent invasion. The question becomes, what's the definition of invasion? Your classic liberal legal scholar says invasion means a foreign army and only a foreign army. Problem is that's not what the history says Constitution. Problem with their argument is that's not what James Madison himself said. You could use it against smugglers. It's anything that goes to sovereignty over land and people. If your sovereignty over land and people is being threatened by some invading individual who's not legally entitled to be there, that probably meets the constitutional definition of invasion. Now, we don't have a bunch of cases that test this, so we have no idea, because when it went to the courts in the 90s over the same problem of immigration, the court said, this is a political question. We're not getting anywhere near this. So we're not going to judicially enforce this. So the question becomes, Abbott, what happens if he's now declared there's been an invasion? What happens if he says we're now at war with and takes people and removes them to Mexico when that is traditionally a federal exclusive jurisdiction of power of immigration? So we're about to find out. But I think some of the people that have assumptions about how that would work don't know the history behind the invasion clause and how actually elastic and broad the word historically was understood to be.
But the press secretary comes out and says immigration is a federal issue, as if to say Texas can't do this, states can't do this. Look, I'm
all
just
foreign
saying,
policy is, but this was always an exception in the Constitution. The exception, just as Congress only had the federal Congress, only people who could declare war, except states could do so if they're being invaded or imminently fear it. And again, they applied it to smugglers. They applied it to people crossing state boundaries when they discussed it at the time. So their assumption, so what you have is a conflict between, and arguably the Constitution resolved it in favor of states. If what's happening is an invasion, they can declare war. And I'm not all that gung ho on this for reasons that should belabor the obvious. I get we want to control illegal immigration. I'm just not in favor of giving governments power for anything because it's almost always going to be misused or abused. But from a purely legal perspective, putting the policy aside, I think they got an argument. The Attorney General for Arizona, Brnovich, wrote a detailed memorandum explaining why that the states absolutely have this power. And I thought his argument was better than the critics' argument.
Robert, I'm going to get to this. Dennis Rogers, I'm going to